watching between Parks Place and Capitol Hill on 6 News, a show all about law and government. I'm Stuart Jeffrey, and today we are discussing the ACT's intersex treatment bill, which has been put forward last month, but is currently up for debate in the ACT Parliament. I'm joined, of course, by Aidan, our parliamentary reporter, and also by Chris Rudge, who is a lecturer at Sydney University and is involved with medical law. Thank you both for joining me.
Thanks, Stuart. Thanks, Aidan.
Thank you. It's good to be here.
So I think probably the first thing to address here with this bill is why have it in the first place? What's the background, of course, because a lot of people, intersex people are only a very small minority of the Australian population. But there aren't even that many court cases that I can remember involving this. So what's the policy reason behind this bill? What's the motivation behind the Labor government in the ACT for putting this bill forward in the first place?
I'm not, strictly speaking, involved in any aspect of the bill. So I, just like any person, but although I have an advantage as a legal scholar, but I come to this like any person, and comment on what I read as the motivations of those who are drafting the bill and those who have advocated for something like this bill for a long time, including organisations representing intersex people and the human rights of intersex people, organisations like Equality Australia, and so forth. So what and also, of course, I read the explanatory memorandum that's published by the ACT Parliament that gives information about what the intention of the bill is. But so as I read it and as I understand it, people who have variations in sex characteristics at the moment, and for time immemorial, probably, for as long as medical interventions relating to them were possible, have effectively been subject to very, very short and sometimes, as has been said by some of the people in support of the bill, coercive decision-making scenarios at the moment of effectively birth, or in that period immediately following the birth of a person who has a variation in sex characteristics. Now, of course, the parents, as the new parents of a child, are in a situation where there is they might have had advance notice if there's some particular disorder identified in a scan at 20 weeks on an ultrasound. But sometimes it would not have had they would not have had advance notice of a particular condition, and upon discovering that there is a condition or a variation in sex characteristics, medical practitioners, accompanying the new parents in those early moments, will disclose it and say, look, we've identified that there's this variation in sex characteristics, and here's what we propose to do. And can you decide, and give us the consent we need to do this right away? It will usually, I can't speak for all these experiences. One of the big problems is we don't have information about any of these experiences other than from those who have, experienced them firsthand. We don't have, a good clinical record of what happens in these situations. Data is extremely poor. And so we'll come to that, but that's one of the virtues and the aspirations of this bill, to actually start to learn about what happens in this decision-making context. But in those moments, parents are asked to make a decision about what they should do about this variation in sex characteristics, and it seems to be uncontroversial, and no one seems to dispute the fact that these decisions could be made in a much more informed way. So, for example, risks and benefits of a proposed treatment could be much better, could be described in more detail. Various considerations in terms of alternative treatments, the most restrictive versus the least restrictive, and alternatives in between could be proposed. But of course, what seems to have been happening, and I don't doubt it at all, but I don't make strong evidentiary claims because the evidence doesn't exist. But what seems to be happening is that these decisions are made without knowledge of the full options that are available to parents. And they are also made in circumstances that parents report later, and those who have been subject to interventions report later, were not really, they felt that there wasn't a choice to not proceed. In other words, they consented in a way that they understood to be as though you would consent to something that was necessary, and only learned later that it might not have been necessary. This just sets up a governance regime in an area where there seems to be a very, there seems to be a gap in governance in medical decision-making. And how it does so, we can talk about in a moment.
Just before, you mentioned there have been situations where it's come out in the future that a certain treatment hasn't been considered necessary. So I guess my question about this is, how do you define, say this bill gets passed, how do you define whether a treatment is necessary or urgent, or I think non-deferrable was the word used in this particular case?
Yeah, so I mean, I must say the bill, I actually really admire the drafting of the bill. I think it's very precise. I think it's, it's considered, it's not just a simple definition, to put it that way. It's considered, and there's exceptions. So it's the way in which it distinguishes between what would be called a medically necessary or urgent restricted medical treatment and one that might be deferrable. It defines urgent restricted medical treatment as a restricted medical treatment required to be undertaken urgently to A, save the person's life, B, prevent serious damage to the person's health, or C, prevent the person from suffering or continuing to suffer significant pain.
Okay.
So so save a life, or prevent serious damage, or prevent suffering or continuing to suffer significant pain. Any of those three things will, if any of those criteria are satisfied, it will be understood as an urgent restricted medical treatment. And if it is considered as such, then the restriction, as it were, would not apply, and a treatment plan approved by a committee would not be necessary. But if it is not within those criteria, then it would be a restricted treatment, and there would be a necessary application made to a review committee set up by this legislation, which involves a number of different specialists. You have 2 medical practitioners, 2 ethicists, 2 human rights experts, and you also have 2 experts in variations in sex characteristics, and 2 people who are experts in psychosocial support. I mean, that's the assessment board. Okay, I'm sorry. The assessment board is made up of those, at least 2 members in each of those categories, and a president. And committees are made up of people drawn from that board, and those committees would determine whether a treatment that is not medically urgent will be approved on the basis of an application.
So I guess, of course the bill deals with older children and even adults, but it definitely includes older children in the regulations. But let's keep working with this example of, newborn babies. And when it comes to this sort of treatment, because that's probably the easiest way to deal with it, is let's say that it's of course, how does the doctor at the point in time determine if it's urgent? Because of course the child's just been born, let's say, how does a doctor determine if something is urgent? Because of course, if it isn't urgent, it would have to then go to the committee.
Yes.
But what if the doctor gets it wrong? What if it was urgent, but he said it was non-urgent? Or what if it was non-urgent and the doctor said it was urgent? What can the parents then seek? Is there compensation? Is there a criminal sentence for the doctor? So if doctor makes the wrong call, what happens moving forward for that doctor and for the parents?
Yeah, so it's an interesting question that takes us forward to some issues that are not addressed by the bill and are left to the common law to sort out, because medical negligence, doctors make mistakes in terms of diagnoses quite often. The general law of medical negligence would still apply, I would expect, because the bill doesn't seek to make a mistaken diagnosis an offence. I think that's answering your question. There's no question that it would be an intentional wrong diagnosis of a restricted versus a provable disorder, right? Because if it is the latter, if there was an intention to avoid, well, let me be clear. There are two provisions that make certain things offences under this bill. The first is to undertake a restricted treatment without board approval. And so that would be a situation where, whatever the diagnosis, you undertake the treatment without doing what the bill requires practitioners, hospitals, etc., to do, which is to propose it to the committee and to have that approval model play out. So there would be an offence for just avoiding the operation of the law, and that's an offence that, from memory, is either 1 or 2 years imprisonment and a fine. The other offence is if a person effectively aided and abetted a person subject to any proposed treatment escaping the operation of this law by taking them out of the ACT. So, for example, a person was because of for whatever reason, and then the parents or anyone else took the person out of the ACT, drove up to New South Wales, etc., and then got a treatment for the intersex condition in New South Wales without going through the board process. If you did that, and I assume you would have to, in a criminal context, prove that there was an intention to escape the operation of this proposed law, as well as kind of you've actually done that, mens rea and actus reus, your mental element, your physical element. If both of those things were satisfied, it's a 2-year imprisonment max sentence for that offence, as well as the fine too. So they're the two offences that the bill proposes. There's no offence in relation to a medical practitioner, kind of wrongfully diagnosing an intersex condition. So the normal medical negligence common law would kick in, and there would be defences, of course, available to any medical practitioner who made an error of that kind, depending on the circumstances. But it's an interesting question, because if an unnecessary and irreversible treatment was non-consensually administered, it would be regarded as a clear case of a common law wrong, and a case of battery, and perhaps criminal battery in some circumstances. So that's my answer.
The case that comes to mind for me, of course, is probably Murray and McMurphy, which is it's a Canadian case, but it was where a mother had consented for a C-section, and the doctor found tumours, and it's like, we're going to tie the tubes as well, which there was no consent for, and they said, well, it wasn't necessary, so you can't use it as a defence. And I like that this bill kind of preempts that and says you can't use that as a defence, because that's often what you see brought up in these sorts of consent issues.
Yes, the defense of medical necessity.
Yes.
Is that yes? Yeah, indeed, and so this effectively puts that question into this shared decision-making model and this supported decision-making model, where what is medically necessary is no longer kind of answered by the practitioner in the moment in a kind of relatively if the practitioner is saying it is medically necessary, the situation can appear urgent. And so sometimes that will be correct. It will be medically necessary and the situation will be urgent, but at other times it won't be. And it's those latter categories that are the aim of the bill, really, because if a practitioner, for whatever reason, was to say this is medically necessary and urgent, and do we have your consent to perform the treatment, and it turned out that it was not, presumably some parents and children will never know whether it was or not. Some might discover later that it wasn't, which is a large part of many of the stakeholders in this area have said that's what's happened to them. But beyond that, if this sets up a guardrail around this process. So, I mean, medical practitioners who have a long practice of doing particular treatments after diagnosing particular sex variation disorders will now kind of have to be guided by the regulations that attend this act. If it is this specified diagnosis, they'll know through the regulations whether it is regarded as medically necessary or not. And that's what the regulations do. And that's one part that's kind of there's still some, there's a proposed draft regulation that sets out a lot of complex, chromosomal, gonadal, and other hormonal conditions, and says, medically necessary, not medically necessary, etc. My understanding is that draft is not finalized, but it is online for kind of viewing and consultation. And I'm still getting my head around, because there's in excess of 30 conditions here. And so what I imagine would usually happen is the doctor identifies the condition, but now they'll have something like this. So you'll get less variation in whether something is regarded as medically necessary or not, because you'll have some actual a uniform instrument in the ACT that kicks in at that diagnostic decision-making moment and might prevent a doctor from saying or suggesting something's medically necessary when it isn't on the regulations. So that's the kind of interruption in this process of diagnosis and treatment administration that the bill seeks to kind of engender.
Moving on a bit, I've got a couple of questions about consent, which is the other big issue there, and we've kind of tiptoed around it here a bit. But when it comes to children, it's very, the law tends to be very restrictive with what children can consent to, but of course this intersex surgery is going to be life changing. So, are there any considerations made by the legislation or by the bill by Labor to allow children to consent to any of these medical surgeries? Of course, I'm not suggesting that, a 10-year-old would be allowed to, let's say 14, 15, 16. Are there any allowances made to those children to have the ability to consent to those sorts of treatments? Because as I said, they are life-changing.
Yeah, and, there will be, there is a statutory definition of, whether it's life-changing or not, will be kind of a question of a few things. Some things will be completely irreversible. Some things will be, so to speak, some things will be reversible, but not without, attendant additional harm and damage through that process. So, yes, I agree. Almost anything will be life-changing to an extent. Some things will be, irreversibly life-changing. Some things will be theoretically life-changing, but may enable some reversal, etc. So the stakes are very high, and yes, in our common law Australia, Marion's case did absorb or adopt into our common law this test of Gillick competence, which is, when a child under the age of 18 will have capacity, like legal decision-making capacity in respect of medical treatments and other purposes, potentially, but the case law is about medical treatments. And the test is effectively whether the child has has achieved a sufficient degree of understanding and maturity with respect to the treatment proposed. So this bill, in my view, does make some attempt to, as it were, codify that test of competence, but it does what a court would do in any event, because it effectively allows an application based on a children's understanding or a child's understanding or wish to be considered by the committee. So the committee that's making a decision whether or not to approve a treatment must consider the wish of a child if it has been expressed and is capable, I presume, of being expressed, because in many cases that might not be possible, where there are, a baby and cannot express a wish one way or the other. But if any wish, and that's the word of the bill, is expressed by a child, then the committee must consider it. Now, the question will probably be, when does a wish of a child qualify? You will have psychological evidence from, psychosocial experts, psychologists who have interviewed children in cases where they're capable of speaking and so forth, and they will be supported to express a wish to the extent that it's possible. And so it's not a direct kind of codification of Gillick, but there's a requirement that a committee will, it must consider wishes to the extent that they can be expressed by children. And in that respect, it's not a direct assessment of whether they are competent to make a decision, but it is an inclusion of a child and of their wishes in relation to a proposed treatment. So to give you a specific chapter and verse, it's section 14. It says, assessment of significant harm in relation to children. When you are determining whether a proposed treatment plan is approved, the committee must consider any wishes the child has communicated in relation to their variation in sex characteristics. So the wish could be do nothing. The wish could be change, take action, etc. The committee must consider that when it's making its decision to approve it or not.
I guess just, but do you think we could see this being brought in, say, Queensland or Victoria, where they also have human rights laws as well?
Yeah, good point. That's right. They do. Those jurisdictions do have those state-based human rights acts. Look, it's an interesting proposal to kind of jump off what we were just discussing in terms of the political, kind of argy-bargy, argle-bargle. The ACT Chief Minister, as I understand, was a very, very strong proponent of this bill. You would imagine you would also want to have someone who is very strongly, in front of any bill in the other jurisdictions as well. I think this is a nationally and to my knowledge, and I think on the basis of this memorandum, an internationally leading instrument. It's something that is doing things that are very, unprecedented, which and coming from the medical regulation space, well beyond, kind of these kinds of treatments. I welcome instruments that are going to create better medical decision making overall. Now, this doesn't create a limit on decisions, in my view. It just makes decision making a little more stepped out and a little more scrutinized. And as long as we don't have a medical emergency, which this bill explicitly kind of carves out as not, part of its application, that's a good thing, to have very rigorous medical decision making where every person who has a view can consider different things and talk about it, etc. It's a bit like, I know these are sensitive topics, but it's a bit like end of life decision making. A lot of people use advanced care directives and engage in discussions well before that critical decision needs to be made in order to resolve themselves to kind of the right way to determine this medical decision, this important medical decision. And I think the principles underpinning, the bill are very appealing as a someone who works in medical law and medical regulation. So I would think in principle, if the bill does and achieves what it sets out to, it will be a very attractive test case, and other states who already have these human rights commitments will adopt it if it proves to work as expected. Now, in that respect, there is a mandatory review, 2 years following the bill's, if it passes, the Act's enactment. And that continues 3 times. So at the 2-year mark, you look back and say, is this working as intended? At the 4-year mark, you look back and you say, is this working? And then at the 6-year mark, you look back again, is this working as intended? There's 3 mandatory reviews for 6 years. So with each of those reviews, I think other jurisdictions will be getting information about whether this has worked or not. I'm sure there'll be commentary around it in addition to those reviews. But so that's one point. The final point I'll make in answer to this question is that it's not a bill that gets passed and then everything changes the next day. It's designed so that there is a slow kind of release, as it were, of the bill, and there's some quite technical legal introductory steps, kind of like if this then that stuff going on at the front of the bill operationally, which is I think perfectly appropriate. And sets up these guide rails in terms of, some of the issues you described earlier, like liability of doctors who might accidentally or otherwise kind of in the middle of these new systems and obligations not know where they are because they've practiced in such a way for 30 years. And now you've got this new kind of regulatory instrument changing the way you perform medical practice. So I think there's a lot of really, kind of smart and technically sophisticated aspects to this bill, and I think that speaks to its long gestation, as it were, in from over a period of years, and I'm interested, acutely interested in how it plays out.
Well, unfortunately, I'd love to keep talking. That's what we've got time for this one. Thank you for joining us again, Chris. If this passes, maybe have you back on again, because I know the ACT also has a free abortion bill up for debate right now as well. So definitely plenty of stuff happening in the ACT right now. We will be back next week. Bring us back as a weekly show. It used to be a weekly podcast, now a weekly YouTube show. We'll be back next week talking about the crown in the lead up to the coronation. Thank you for joining us, and we'll see you next time.
Thanks very much.